say you. Thank you, President Saunders. Caribbean Court of Justice, Original Jurisdiction, Case Management Conference in AGOJ number 1 of 2021 between Ellis Richards, Medical Benefits Board, Spencer Thomas and others, and the State of Trinidad and Tobago. The members of this morning's panel are Mr. Justice Saunders, President and the Presiding Judge.
Good morning, everyone.
Mr. Justice Witt.
Good morning, Counsel.
Mr. Justice Anderson.
Good morning, everyone.
May we have the appearances, please? Thank you.
May it please your honours, I, Simon Davenport, Queen's Counsel, continue to represent the claimants, and with me are the following attorneys: Dr. Kenny Anthony, Robert Strang, Gregory Pantin, George Kernan, Rafael Ojodia, and we are instructed by Miguel Vasquez.
Yes, thank you. Morning again.
Your Honor, should it please you, Mrs. Deborah Peake leads me tomorrow Tuesday for the state of Trinidad and Tobago, and we are instructed by Mr. Brent James and Ms. Carissa Singh.
Yes, thank you, Ms. Tulsi. Ms. Peake, are there any further objections to the application to file the reply, which have not been alluded to in the affidavit of Carissa Singh?
Well, Your Honor, there is no objection. We simply wanted to put before the court the correspondence exchange between the parties, in which you will see that we were seeking, they had invited us to give consent, and we had simply responded and said, let us have sight of the draft. But I would not take it, and I would not ask the court to take it as an objection. In fact, we are not objecting to the filing of the reply. It's just that we thought it would have conduced to the more efficient management and the setting of timelines if we had and the court had sight of the draft. But if that's not the claimant's position, we're entirely in the court's hands.
I understand. Would you want to file a rejoinder?
Well, yes. And of course, the difficulty is until we see the reply, we're not exactly sure that we will be required to do it and how extensive that pleading will be. So I expect one of the first orders of business is for my learned friend, Mr. Davenport, to indicate the date by which the reply is to be filed. They've had our defense for 8 weeks now, so I'm thinking we should be given an equivalent.
We will get to that. We will get to that. We will get to that.
Yes, much obliged.
Yes. Mr. Davenport, how soon can you file a reply?
Your Honor, I would say it's no less than 28 days from today.
28 days.
28 days.
And do you have any objection to the defendants filing a rejoinder?
No, I don't have any objection at all. I think it's a good idea.
Okay. Now, this case took over 10 years to reach us, and I think everybody appreciates that it isn't going to leave us for a little while. In particular, given the length of time that I'm hearing that persons would need to file replies and rejoinders and that sort of thing. So I just want to put that on the table right at the start. If you have a month to file your reply, that would carry us to today is the 9th of March. Yeah. Okay. That would be some recalibration on our part, but the 9th of March. And Ms. Peake, let us put aside how much time they took with whatever. What is the shortest time within which you can file a rejoinder?
Well, Your Honor, I would say a reasonable time rather than the shortest time, bearing in mind we're talking about events that occurred 12 years ago, 13 years ago now, would be 2 months.
So that carries us into March, April to May, the 9th of May. Okay, the bench is going to take a short recess so that we can recalibrate our time. Stay on the line, don't come out, and you will just excuse us for a short time. Okay, what we are minded to do is to agree those dates. So the reply will be filed by the 9th of March, the rejoinder by the 9th of May. I haven't checked to see if any of those days is a weekend or so, but it doesn't matter really. And we are going to schedule a second case management conference for the, someone remind me what the date is again? The 14th of June.
14th of June.
Yes. Is that a convenient date for everyone?
It is for the defendant, Your Honors.
Yes.
It certainly is for me on behalf of what is a very large claimant team. I'm hoping enough of us will be able to make that date, Your Honour.
Sure. Okay. Now, there are a number of issues that have been raised. One is the issue of the claimants, the actual and potential claimants, the large number of both actual and potential claimants. Of course, those who are already claimants, we have to deal with them. They are claimants. Those who are the potential claimants, we propose that on the 23rd of June, we can have further discussion on that issue.
The 14th of June.
The 14th of June.
Sorry, the 14th of June. So far as the actual claimants are concerned, we are going to ask the Claimants Council to prepare a document that categorizes them in the very helpful manner that you've suggested, by name, nationality, whatever the instrument that they hold, or the various things that you helpfully indicated, and to, but let me put it to you. When would you be able to serve that list on the defendants?
I believe that we would be able to serve that list by the same date as the reply. So that's by the 9th of March, 28 days from today's date.
Okay, so that because the sooner they get that, the better, so that you'd file both your reply and the broken down list of claimants by the 9th of March. The defendants will file their rejoinder by the 9th of May. There are two other issues that have been either raised or been foreshadowed. One is the issue of disclosure. Clearly, there may be things that will be raised in the reply and in the rejoinder on which you may seek to have disclosure on as well, so that we think that it might be a little premature to address that issue now, even though it could be taken in relation to the originating application and the defense, but there are more pleadings coming in. So let us defer that issue for the time being. There's another issue which we want to put on the table and defer, and that is the points that have been raised in the defense that speak to either the inadmissibility or the jurisdictional issues or what one may call knockout issues, assuming that everything in the originating application is true. We would want to put that on the table on the 14th of June as well. It is likely then that we could make orders appropriate to the defining of those knockout issues and the manner in which we can have a discrete preliminary hearing on them, so that, well, we think that may be an efficient way of proceeding. So I just wanted to make those things clear at this point. And as far as we are concerned, those are the major issues which we think we want to address today. Mr. Davenport, is there anything that we haven't dealt with which you would want us to deal with?
No, it's extremely efficient, if I may say, and thank Your Honours for it. And that speaks of a lot of pre-reading and preparation, where all the parties are very grateful to Your Honours for that. Thank you also for raising these other issues which we can contemplate. Although I suspect that the court's answer will be that you will deal with that on the 14th of June, I think we were proceeding upon the basis that there were to be no knockout blows and that would be wrapped up within part of the trial itself. And that followed from the granting of permission that this court gave some months ago. That's really my only observation. I might have answered my own question, but I just thought I would raise that as it was in my mind.
Yes, Ms. Peake?
Much obliged, Your Honour. We're very happy for the points that the court has indicated it wishes to be addressed on the next occasion. And certainly in relation to the last point and the knockout points, as you had indicated, to use your language, that is precisely what we were going, that is the approach that we were going to commend to the court. But of course, we will deal with that in some more detail when we're next before you. But we do think that that is an efficient way of proceeding when you're dealing with 541 claimants whose position may be different in relation to themselves and, in fact, others. So, no, I don't think there's anything else we think we need to deal with at this stage. We're very happy to proceed on the basis that you've indicated.
Okay, there's one further point that I don't think I raised, and that is the second case management conference is listed for the 14th of June. We are minded that on the 7th of June, and I'm thinking whether that may even be too late, but on the 7th of June, by the latest, the 7th of June, each side will file a document indicating the kinds of orders that you would like the court to make, or the points that you wish the court to address on the 14th of June, so that we go in on the 14th of June with each side knowing what the other side is going to be asking for, and the court will have a sense of what kinds of orders it has to consider making.
And just for clarification then, Your Honour, there's not going to be a determination of such supposed knockout issues.
No.
It's going to be making directions for the further contemplation.
That's right. Because if we were, for example, to table, whether, for example, Article 30 is a complete defense, then we would need to hear argument, written submissions, first of all, and then argument. We'd want to set a timetable for all of that. And that is what we would likely do on the 14th of June.
Very grateful.
Yeah.
So, Your Honour, can I inquire? So, what you have in mind is perhaps a draft order for the.
Not so much a draft. Well.
Or draft directions as
yes,
the parties think appropriate.
Why I hesitate about draft orders because I'm sure that it would have to be tweaked and mangled, and so that it's really the points which you wish to have addressed more than a formal order that you set out.
We are guided, Your Honour.
We're very grateful. Very clear.
And well, we thank you so much for your cooperation. This has been short and sweet. I think that is all we can accomplish today. We will drop a formal order embodying what we have agreed, what the court has ordered, and that will be served on you as soon as practicable. So thank you very much. And Madam Deputy Registrar, you may close the proceedings.
Thank you, President Saunders. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.